It's better for somebody to use this one.
But you can use this to change.
Okay, I can use this. Yeah.
And you can choose, and obviously you can move this way. Great.
Okay.
So you propose to stay with the podium?
Yeah.
Okay, great. And what else?
Just turn it on right now.
So be able to see without turning around.
Great. Thanks, John.
Is there anything else you need?
That's it. Thank you. Well, thank you all for coming. Many thanks also to Mr. Kenji Kuroda, who I will introduce in a moment. It's great to see such a big crowd here today, demonstrating once again the tremendous interest in things international that we have in the law school. And it's really great to see such a big crowd. Many thanks to Helene Ducrot for organizing this event and much of Mr. Kuroda's trip. And most of all, we're very thankful to have him back at Duke for the first time in 15 years. He received his LLM from Duke Law School in 1989, and as he told me, this is his first trip back. So since that time, Mr. Kuroda has had a number of different positions. He currently, and since 1995, has run his own firm in Tokyo, where they have a special focus on intellectual property area and as that relates to business transactions. In addition, they do a lot of work with China and direct investments into China. Mr. Kuroda speaks Japanese, English, and Chinese. He is also admitted to the New York Bar, studied at Waseda University as well as Fudan University, and I will let him get right to the subject matter at hand. Again, thank you very much for coming, and thank you, Mr. Kuroda, for making this long trip to be with us yesterday and today.
Thank you very much. My name is Mr. Kenji Kuroda. I'm an attorney practicing law, and I was admitted to the bar, about 19 years ago. And although I look, very young, but I'm, already 41 years old. And then I have my own office. I run by my own office, with a one recently made partner, who is also graduate from Duke Law School in the year of 2001. And then our firm has been, very specializing in a specific area of law, which is intellectual property law, as well as Chinese law. Today, I'd like to speak about, recent developments of the, intellectual property enforcement, primarily in Japan, but also some of them in China. Some of the students here may know about the location of Japan. Japan is close to China, and you can fly from Shanghai to Tokyo with only a couple hours. Just like between Durham and New York. And in order for the Japanese companies to enforce the patent intellectual property rights in Japan, we think we need to have a close cooperation with the attorneys in the different jurisdictions, including the United States and Europe and China. Nowadays, we have to understand the strategic strategies for enforcing patent and copyright and trademark rights all over the world, including Japan, the United States, and other countries. So, before I get into the detail about patent infringement lawsuits in Japan, I'd like to introduce a little bit about how our firm has been doing about IP laws. I have been representing the FIFA, which is the World Soccer World Cup soccer event organization, and then remember that we had a World Cup soccer event in the year of 2002 when Japan and Korea hosted the events. our firm has been prosecuting a trademark and copyright, actually trademarks in Japan for FIFA, and then we're assigned to develop the strategic plans to prevent counterfeit goods from being exported from China and South Korea, and then we appointed a Chinese law firm to set up plans for preventing those counterfeit goods from being exported at in every important port of China, and then our firm has been applying for the applying for the Japanese custom offices to stop those goods from China and Korea. And the Korea's law firm, which is the biggest law firm in Korea, also took a role of reporting to the police and the custom office in Korea. So when I was representing FIFA at in the year of 1998, when the World Cup event was held in Paris, there are over 200 trademark litigations all over in France, in just one country. So we were expecting that more than 100 litigation would be initiated by our firm in the year of 2002, because Japan is much closer to China, which is the world largest counterfeit goods manufacturing countries. So because of the close coordination among the three law firms in China and Korea and Japan, we actually did file only one litigation in Japan, and we didn't have to use any legal means to stop those importation from China of those goods. So we did a very remarkable job because of these close collaborations. One another work our firm has done before is to advise our clients in choosing the forum for the patent infringement actions or defensive actions in England, United States, and Japan. Different country has a different legal system. In order for our client to be effectively defending its position in patent disputes, we must be able to advise our client as to where we should file so-called declaratory judgment actions, which means alleged infringer of patents must be able to take initiative steps to defend itself by filing an action to confirm their position, which means non-infringement of patents or the invalidation of patents. For instance, in the United States, in order for you to be able to file a declaratory judgment action, you must prove that there is a reasonable apprehension of lawsuits by presenting evidences such as a warning letter received by the alleged infringers from the patentees. If the letter is not so strong enough to create a reasonable apprehension of the lawsuits in the United States, you cannot file so-called DJ action. DJ action means a declaratory judgment action in United States. But in Japan, if there is any disputes or different opinions among the patentees and alleged infringers, then the alleged infringers may file a DJ action in Japan. So, if you are admitted to to the bar in the United States, and then you act as if every legal system or laws in different jurisdiction is almost same as the United States, that's clearly wrong. You must be able to understand the difference between the American legal system and other countries' system. So when I represented one of the Japanese clients, we took the advantage of the difference, of those systems in the different jurisdictions. Our clients, was able to file, actions firstly in United Kingdom to nullify the patents granted to the patentee, and then under the patent law of the England, we could initiate such actions. Also, the reasons for the invalidation of the patents could differ, depending on the jurisdictions. And we analyzed a lot about, the opponent's patents in England and in the United States and Japan. We found that it would be easiest for our clients to invalidate, the opponent's patents in United Kingdom. So, we found that, you can action in UK, and we successfully, got the, royalty-free license for our client. And then we thought that our clients would be able to, make a settlement agreement with, the opponents, for all the patents all over the world. But the opponent, refused to, settle. Then we initiated the, legal action in Japan. Again, we, successfully won the, judgment before the, Japanese, court, which is a Tokyo District Court. Will be, and I'll be explaining a lot about, how we should, make a strategy in patent infringement action in Japan. Then we, lastly filed, DG action against the opponent in District Court of Washington D.C. Because there is a one case law supporting that our position, which means if there is any patent disputes, patent litigation outside of the United States, we can prove that there is a reasonable apprehension of the lawsuits in the United States. So, because we initiated the lawsuit, prior, before we, came to the United States, we could, manage to prove that there is a reasonable apprehension of the lawsuits in the United States. Then, again, we successfully entered into a settlement agreement after the Markman hearing took place. Markman hearing, probably you may not, you don't know the Markman hearing, but the Markman hearing is the hearing for the the claim interpretation, in the United States. In the United States, if you have the court ruling on some of the terminology used in a patent claim, virtually you can win the case. So if you were just a U.S. attorney and then you just know about the U.S. court system and the U.S. patent law, and you'll never be able to get the same result which your firm obtained. So those two stories, I can offer to you about how important how important is to know the difference among the laws in the legal systems in several countries. Okay, so I'd like to begin with this material. So, what is the focus of the strategy? When as a lawyer, we, as a lawyer, we must think over and over again about the strategy. What sort of final solution is considered most desirable, to our client. We have to, repeatedly, ask your clients, ask yourself. Do you want the infringer's capacity to do business eliminated? Which means, do you want to kick out your enemy out of the industry? This is one possible, solution. Secondly, do you just want to, money? Do you just want to have a compensation? Thirdly, do you want to, enter into any, license agreement whereby, your opponent and you, can coexist in the same industry, and then you can gain a, reasonable amount of, royalties by entering into those license agreements. So the first one is complete victory, and the second one is maybe second victory, and the third one is maybe a third victory. But if you want to, kick out your enemy out of the industry, you have to be, well prepared for, the counter attack by the opponent, and you have to spend a lot of time and energy and money. So we have to think over and over again, which would be the, most desirable in the, given the, the situation. And there are many means for the solution. We can initiate, settlement negotiations after sending a warning letter. There are other ways, such as you can, file a demand for a permanent injunction, and then you can make a demand for the, monetary damages. So there are, many means for the solutions. And then nextly, I like to, explain about the patent infringement lawsuit procedures. There are, possible, pre-trial measures to take. Pre-trial measures means before, resorting to the legal means, you have some, so you have something to do. For instance, sending a warning letter, or you initiate settlement negotiations, or collection of evidences. You can make your evidence perfect before you go, get into the, trial. After you decide to take a, legal action against the opponent, you have a number of, means and procedures. You can file a, application for the provisional disposition for temporary injunction. You can call it, preliminary injunction, or any other, ways in English terms. And then secondly, you're going to initiate normal civil procedures. That is here it says a trial on the merits. And then we can file a, criminal complaint against, infringers. Fourth one is we can file the, applications to order for the restraint of importation under the custom tariff law. The application is filed with the Japanese custom offices. Firstly, I'd like to discuss about the sending warning letter. And actually, in some jurisdictions, in order for you to be able to file a lawsuit, you must send a warning letter. In Japan, that's not a requirement. You can choose not to send any warning letter to the infringers, or you can send. And there are the advantages and disadvantages of sending a warning letter. For instance, if you send a warning letter to alleged infringers' customers, that could trigger the legal action against legal actions to be taken by the alleged infringers under the Prevention of the Unfair Competition Act in Japan. For instance, in the event that the patentee sends a warning letter to the customers of the alleged infringer, and later on, you get the decision of a non-infringement or invalidation of a patent, then the patentee will be liable for damages incurred by the alleged infringers. So you must be very careful when you decide to send a warning letter to the customers of the alleged infringers. And there are a number of advantages and disadvantages of the sending a warning letter. Of course, one of the advantages is you don't have to incur the a lot of costs, for the patent infringement actions. So you can reach in a settlement agreement, and thereby you can reduce your cost. And then there are a number of disadvantages, such as if you send a warning letter, that would give the alleged infringers sufficient lead time for the defense preparations. Some infringers definitely take advantage of taking time to respond to the warning letter, so that they can consult with their lawyers, and they can initiate some legal actions for invalidation of patents. Or sometimes the infringers may initiate to file a declaratory declaratory judgment action for infringement. Also, patentee may lose opportunity to select a forum of its choosing. In the United States, it is very important to choose the appropriate forum for the patent infringement actions. You may have heard about the word rocket docket, which is Eastern District of Virginia. If you want to if you're representing a patentee in the United States, usually you want to put the great pressure on the alleged infringers by filing a infringement action in one of the jurisdictions in the United States, which is the Eastern District of in Virginia. From the date of the filing until the start of the trial date, in the rocket docket, you have only maybe 5 months to 6 months. If you file infringement action in New York or in California, then you may have to wait until a couple of years to get to trial. So if you want to represent a patentee, then you have to consider where you should file a legal action. The same things applies to Japan. I can explain it to you a little bit later on about which district court would be most desirable for the patentee. And if you send a warning letter to the alleged infringer may file declaratory judgment actions in the forum where the alleged infringer thinks it's most desirable to defend themselves. Next is a trial. I like to explain to you about parties, jurisdiction, and timing of filing a lawsuit, and trial proceedings and discovery. With respect to the parties, of course, we have a plaintiff, and then what shall we do about the defendant? We cannot just file a lawsuit against a alleged infringer as a defendant. We usually advise our clients to conduct investigations about the defendant. Firstly, we try to understand the defendant's business profile, where their main offices are located, where their branch offices are located, where their sales offices are located, and what kind of lawsuits they have before, and then how rich the defendant are. The financial standing is very important. If the defendant is not rich enough to be able to fight against our client for many months, then you can use different strategies. Also, you cannot expect to be able to get the real monetary compensation from the defendant. And then also, we have to conduct investigations to specify the relevant products or manufacturing process of a defendant. In the United States, if you have rationale to bring a lawsuit against any of the parties, and without knowing the specific products or manufacturing process, but you still can manage to file a lawsuit, and then you can initiate the discovery, so that you will be able to identify the products and manufacturing process of the defendant. But in most of the jurisdictions, the U.S. legal system is very peculiar, and if you just study American law, and probably you'll be very blind to the other jurisdictional legal systems. I can say that in almost every jurisdiction, you have to be able to specify the relevant products and the manufacturing processes of the defendant. Otherwise, you will lose it case. Even if your client is right, you have to prove yourself. You have to prove what you assert in the lawsuit. And then we also conduct an investigation to specify sales and manufacturing locations. This is really important for our client to choose the appropriate forum, appropriate court to initiate a lawsuit. Next issue is jurisdictions. Actually, prior to the last year, we could file patent infringement actions in any district court all over Japan with some requirements. But now there are two exclusive jurisdictions for patent infringement actions in Japan. One is the Tokyo District Court. The other one is the Osaka District Court. If the location, if the whereabouts of the defendant's main office is in the western part of Japan, you must go to Osaka District Court. If the location of the defendant's main office is in the eastern part of Japan, you must go to Tokyo District Court. This is one principle. But if the defendant's sales office is located in a different part of Japan, then you can go to the different district court. For instance, one company's head office is located in Fukuoka, where the Duke Summer Program is held this year. You'll go to Osaka District Court, but this company may have a sales offices in Nagoya or Tokyo or Yokohama. Then you can choose to file a lawsuit against this company before the Tokyo District Court. And then third one is place of the infringing activities. If the company's headquarters is located in Fukuoka, but they have factories in the eastern part of Japan, then you can file a lawsuit before the Tokyo District Court. And then the fourth one is the location of a party's main office, a plaintiff's main office in the event of demanding compensation for damages. The patent infringement lawsuit usually takes form of a lawsuit to demand a permanent injunction together with demanding compensation for damages. If you simply ask the judges to permanently forbid defendant from manufacturing or selling, then you must choose the district court depending on the location of the defendant's main office or seller's office or defendant's infringing activities. But if you want the court to order some monetary compensation for the damages, then the plaintiff's main office could be the factors for you to decide which court you're gonna file a lawsuit. For instance, if your client has a headquarters in Tokyo or Yokohama, then you can file a lawsuit in Tokyo District Court by demanding compensation for damages. Trial flow. So, when you go to Tokyo District Court or Osaka District Court, and then any party can make a appeal to the higher court. And when under current legal system, you have to go to Tokyo High Court, and then if you want to make appeal to the Supreme Court, then there's only one Supreme Court in Japan. then those courts will decide the issues as to whether the patent is infringed and whether the patent is valid. Actually, before the April 11th of 2000, which is the date of one of the very important case of the Supreme Court, was decided. Those courts may not decide whether the patent is valid. The issue as to whether the patent is valid used to be decided only by the Japanese Patent Office. But since April 11, 2000, like the United States courts, those judges of the courts can decide both of the issues, which means infringement and validity issues. There is another flow of the patent litigation, which is appeal against the trial decision of Japanese Patent Office. The alleged infringers usually file, the demand for the, invalidation trial against the patentee before the Japanese Patent Office, which is abbreviated as here, JPO. And then after the JPO's judgment was rendered, and either party may make appeal to the Tokyo High Court, and then against the decisions by Tokyo High Court, you'll make a final appeal to the Supreme Court. The only issue which they can try before the Japanese Patent Office is validity, which means whether the patent is valid. Here is a statistics, I can show it to you. It's a trends in IP litigation at the district courts level, the first instance court level. As you can see, number of intellectual property related civil cases newly filed or decided increasing every year. Also, there is a average trial period. Trial period means from the date of the filing a lawsuit until the judgment is rendered or the settlement before the judge is attained. As you can see, in the year 1991, the number of cases newly filed is 311. And you can see that in the year 2003, the number of cases newly filed, for the year 2003 is almost double, 635 cases. Also, the number of cases decided in the year 1991 is only 386. But the number of cases decided in the year of 2003 is, 615. And then the average trial period, which means in a month in decided cases in the year of 1991 is 31.1 month, which is almost 3 years to get to the judgment. But in the year of 2003, you can see only 15.6 months, is needed to get the judgment. So you can see, many foreign, lawyers, including U.S. attorneys, think that Japan is not a litigious, country, and everybody can make a settlement out of the court. And then once you go to the court, it will take, time and, but that's not true in Japan. I have litigations. I have been handling litigations in China, Malaysia, and Indonesia, and sometimes in England, India. I have cases, which I represent one of the Japanese banks in collecting, loans from Chinese, companies. I filed a lawsuit, 8 years ago. I thought that it's easy case, I thought I could get the judgment within a couple months, but 8 years passed, still I cannot get the judgment from Chinese court. I successfully managed to get the preliminary injunction order one of the Malaysian, companies, in the year of 1990, I think 1997 or 1997, yeah, 1997. And then I thought that the trial would begin, within 1 year, but the trial began, last year. So it took 7 years to start the trial in Malaysia. I had a litigation in Lebanon and in Middle East countries. When I was first year associate, I was assigned to handle the litigation in Lebanon, and then I thought that the case would be over maybe a couple of years, but it took almost 17 years to get the Supreme Court judgment. During those periods, because of the war, sometimes the case was didn't work for about 5 years or 6 years. So, but here it's you can see in Japan you can easily get the judgment. Some in comparison with New York courts or California courts, it's a lot faster than the courts in the United States. So you have to be prepared, well prepared for the patent infringement action in Japan. This is, average trial periods for first instance cases. As you can see, the number of periods, number of months to be used by the Tokyo District Court is very small. For instance, in the year of 2002, which is a fiscal year means that 2002 fiscal year means the year starting at 2001, I think April 1st to 2002 March 31st. Usually, Japanese financial year or accounting year, begins at the first day of April, and then only 11.3 months is needed by Tokyo District Court, and then 12.6 period. 12.6 months is needed by Osaka District Court. You can see, the courts of the, the cities other than Tokyo and Osaka usually needed more time, or longer, to, finish the cases. This is trends in IP litigation in a high court level. Number of intellectual property related to civil cases newly filed or decided, and average trial periods. You can see in the year of 1991, the number of cases filed is only 7.78, and then average trial period in decided cases is 13.3 months. And the next year, to 1992, it took 17.3 months. But now in the year of 2003, the number of cases filed is 183, and then average trial period is 9.9 months. So you can get the quick decisions before the high court in Japan. I think this is really faster than most of the courts in advanced countries such as the United States and Germany and England. This is organizational structures of IP divisions of Tokyo and Osaka District Courts and Tokyo and Osaka High Courts. Tokyo's District Court has 4 divisions, and they have 16 judges plus 7 technical law clerks dispatched by the Japanese Patent Office. Usually judges do not have a technical background, and they need to have assistance from the technical law clerks sent by the Japanese Patent Office. Although if you think that the Japanese Patent Office may try to influence over the judgment to be rendered by the judges, but that's not true, because the technical law clerks dispatched by the Japanese Patent Office, should be able to entertain its independent position, so they can they can decide, they can give the advices to the judges purely based on their personal judgment. And Osaka District Court has two divisions, and they have 6 judges and 3 technical law clerks. And Tokyo High Court has 4 IP divisions with 18 judges and 11 technical law clerks. And then nowadays, Japanese Supreme Court and Tokyo High Court is very proud of themselves about this high number of judges specializing in IP cases. So they have the capability to render the judgment with a reasonable period of time. And Osaka High Court has 5 judges in 1 division and with 3 technical law clerks. There are characteristics of respective IP divisions of Tokyo and Osaka District Courts. I'll explain later. 29th Civil Division has a famous judge Mr. Imura, and the 40th Civil Division has the chief judge of Mr. Ichikawa, and the 46th Civil Division has the most famous IP judge Mr. Mimura, which recently rendered a very famous judgment, which gave one of the most famous inventors for creating blue LEDs, light emitting diodes, $200 million as a compensation for his inventorship. His company is dominant in the industry of the blue LEDs and white LEDs. The company is called Nichiya, which is used to be very small company with only I think maybe $100 million revenue per year. But nowadays, their turnover is over $2 billion per year, and then profit they make per year is above $1 billion. And those profits are said to be coming from the Professor Nakamura's inventions. Professor Nakamura is now working as teaching at the University of California, Santa Barbara. He'll be considered to be one of the candidates for the next Nobel Prize in physics or chemistry. It is amazing to hear that the one employee who invented one technology, one patent, got $200 million judgment. Actually, the lawyer representing Professor Nakamura was my ex-boss, Mr. Masunaga, and then because of the requirements for filing a lawsuit in Japan, they couldn't demand the amount more than $200 million. The judgment says if the plaintiff demanded $600 million, he could get the $6 million. So now this case was being disputed before the Tokyo High Court, and then the law firm representing the Nichiya Corporation is the largest law firm in Japan, and who sends 3 LLM students to Duke Law School this year. I don't know how the result would be. And then 47th Civil Division has a presiding judge, Takabe. She's the only female, presiding judge among 4 chief, judges. Osaka District Court has 2 divisions. One division is 21st Field Division. Presiding judge, the chief judge is Mr. Komatsu. He is very famous for the speedy trials. Actually, when I successfully, represented one of our clients, we, intentionally dropped the lawsuit before the, pending before the Tokyo District Court, and then I, after that, immediately after I dropped it, we dropped the lawsuit. we filed a lawsuit in Osaka District Court because we wanted to make a speedy trials before the Judge Komatsu. There is another division, which is the 26th Civil Division. Judge is Mr. Yamada. I don't know anything about Mr. Yamada. I think I explained a little, already a little bit about judge, each of the judges. Mr. Imura, he's also very famous in Japan. He has a tendency to form an impression or his thinking as to the outcome from early stages of proceedings. As a result, once he decides something, he's very difficult to turn over. And the proceedings are handled very speedily. And then trials on the merits and provisional dispositions are most handled by a panel of 3 judges. In some divisions, only 1 or 2 judges handle the provisional dispositions. And in this particular divisions, all of the 3 judges consider the case at the same time. One of the famous cases is what they call the Apple computer case in Japan. Apple computer filed application for the preliminary injunction against the company called Sotec, which is manufacturing personal computers with a very similar designs of the Apple computer with transparent figure. And then the lawyer representing Sotec didn't file any papers at the first date of the trial. And then Mr. Imura got very angry and then decided in favor of the Apple computer. But actually, that case should not be judged in favor of the Apple computer. And many IP lawyers in Japan thought that was wrong. The case was, later on settled before the, Mr. Imura. But this kind of things happen even in Japan. If you think that Japanese people are very patient, but that's not true with Mr. Imura. So, and then again, Mr. Mimura. He's the guy who rendered the 200 million US dollar verdicts in favor of Professor Nakamura. He also has a tendency to form an impression as to the outcome from early stage of proceedings. And amending a patent claim may sometimes result in a suspension of proceedings. Usually in other divisions, the judge will not suspend the procedures even in the case of the claim amendment. And then preliminary procedures are handled by presiding judge Mr. Mimura and 1 other judge. And the provisional disposition is handled by 1 judge other than the presiding judge. So there are a number of ways to handle the cases, depending on the divisions. And then I had a experience in turning over Mr. Mimura's impression in the past by presenting videotapes. Actually, this morning I had a chance to talk with Professor Lang, and he asked me what benefits you from studying at the Duke Law School. And then I told him that the way presenting a cases in a U.S. court, is really advanced, and then I adopted the way of American lawyers, presenting the cases to the jurors. I think in most of the countries other than the United States, lawyers usually write the briefs without any videotapes or any this kind of computer graphics or PowerPoint presentations. But nowadays in Japan, it's very difficult to change the judge's impression. Once the judge thinks in this case should be decided in one party's favor. And I clearly remember that when I presented one videotape to the Judge Mimura, and then I think during the lunch break he watched the videotapes, which explains how the technologies should be interpreted. We spent I think 50,000 US dollars to create one videotapes, with 30 minutes. And he asked me, Mr. Kuroda, did you write same contents in your brief as those shown in videotapes? I said yes. So at that time, I felt that the judges, never really read our briefs. Instead, he watched the videotapes to understand the case. We're very fearful about he's rendering a preliminary injunction order our clients. And once our clients receive that preliminary injunction, then our clients must stop their production and selling the products. So our clients was very happy about making a videotapes to change his mind. And Judge Takabe, she's the only female lawyer presiding judge in IP divisions. She's a brilliant judge. She used to be a law clerk of a Supreme Court up until this past March. She has had a great deal of experience in the IP cases. And then litigation was handled by a panel of 3 judges, namely presiding judge and 2 other judges. When Mr. Takabe was the presiding judge of a 29th Civil Division in 1998. About Judge Komatsu, he is also taking very speedy trial, and that's why I told you that we wanted to have the cases before him. His characteristics is to make a plan, like U.S. judges. He likes to have the schedule for every single event. So maximum 300-day period from filing to conclusion of all proceedings targeted. Tokyo District Court has a 40th Division, Mr. Ichikawa, and Osaka District Court has a 26th Civil Division with the presiding judge of Mr. Yamada. We don't have much information about them. It remains to be seen how they will direct as a presiding over in IP divisions. Actually, my ex-boss, who represented Professor Nakamura, got a 200 million US dollar verdict. According to the news source, my ex-boss, Mr. Masunaga, the richest lawyer in Japan for these 3 years, filed three complaints at the same time before the Tokyo District Court in order to, get one of the cases, assigned to the presiding judge, Mimura, and then he dropped out, 2 other complaints before the complaint is properly, served on the defendant company. It is very unusual for a lawyer to file 3 different complaints covering the same subject matter in order to get the case assigned to a particular judge. But my ex-boss did it and then got the $200 million verdict, some judgment. And I'm sure that he will get at least some percentage of the the money which Professor Nakamura will get. They're like a U.S. attorneys, right? And then here is the patentee's winning rate in trials on the merits. As you can see, the patentee's winning rate is very low. You can see in the year of 2004, the winning rate is only 19.35% for Tokyo District Court, and then 33.33% for Osaka District Court. The reason why the winning rate is so low is in most infringement cases, if the plaintiff is about to win the case, the defendant usually, wants to settle the case by paying a settlement amount. That's why the winning rate for the plaintiff patentee is low. You can see that the winning rate for the Osaka District Court is very high. That is one of the reasons I wanted to file a lawsuit against the infringers before the Osaka District Court. The timing of the filing a lawsuit, we have to consider many factors. One is the statute of limitations. You have to file a lawsuit within 3 years after that. You know the infringing activities and damages. You have to collect evidence. You also have to consider the many business factors, whether settlement negotiations are necessary, how much it would cost, and then how much the defendant's operating profits are, and those factors we have to consider. Next is the trial procedures. There are, procedures for the provisional disposition and trial on the merits. As I explained to you, there are two demands for permanent injunction and compensation for damages, and criminal complaint and restraint of importation under custom tariff law. We have to be careful about the difference between the restraint of importation under custom tariff law and then United States ITC investigations. For the provisional dispositions, there are some characteristics and procedures. In patent infringement cases, court hearing is held as a rule, and substantial infringement issues are discussed. And decision of enforcement can be executed before service on the alleged infringer, which means you can enforce your judgment before letting the alleged infringers know about the result. Okay. Yeah, I think we are running out of time, so I have to speed up the. And then advantages for the provisional disposition procedures is the cost. Cost is really low. Also, you can expect a very quick decision. What are the disadvantages? You have to put the security deposit. Also, if you lose the trial on the merits after enforcement of the provisional disposition decisions, you'll be liable for damages incurred by the alleged infringers. Trial on the merits. I think I explained, before. I skipped this. There is one characteristic which is very similar to the U.S. patent infringement actions, which is there are bifurcation of the infringement issues and damage issues. And once the judges form his idea about the infringement or invalidation, the judge will instruct parties to proceed on the issues of damages. Once the judges direct both parties to proceed to argue about the damage issues, which means the alleged infringers will lose the case. The only issue left there is how much the defendant has to pay.